Chapter 8, Occupational Health and Safety Legislation. So in this chapter, we'll be looking at understanding the internal responsibility system with regards to health and safety in BC. We'll also outline health and safety duties of all parties in the workplace, employers, workers, contractors, anyone in the workplace. We'll also identify the workers' rights and also understand the legal requirements related to violence and harassment. And we'll finally explain how legislation and regulations are administered and enforced by the Workers' Compensation Board, and look at the test of due diligence, which is an important defense for employers. So when we talk about occupational health and safety, we should keep in mind that this may pose the main source of potential legal liability for employers. So employers may face administrative penalties. They may even face prison time if they do not comply with their occupational health and safety duties and obligations. And in each and every province here in Canada, there's extensive legislation to prevent accidents and illnesses that result from work. And in an unfortunate event, they take place. Legislation also deals with compensation for those accidents, injuries, or illnesses. So the main characteristics of the legislation are to prevent accidents and injuries. So that's the top priority. So whenever we are able to prevent, there's no need to remedy. And then a second characteristic is to enforce occupational health and safety procedures and standards because they go in harmony with prevention. But then in case prevention was not successful in particular events, the third characteristic will be to compensate employees that are injured or who have acquired an illness related to work. That we will be dealing with in Chapter 9 when we talk about the workers' compensation. So the Occupational Health and Safety legislation is basically in the Workers' Compensation Act, the BC Workers' Compensation Act. This act will deal with consequences of workplace injuries and illness, and also compensation and rehabilitation of injured workers. And Part 3 deals with occupational health and safety, and we'll be most looking at Part 3 in this chapter. We also have the Occupational Health and Safety Regulation. There are several regulations, and they deal with a more detailed regime for the prevention of workplace injuries and diseases. One of the requirements of the main regulation is that companies, they have a management system for occupational health and safety, and such a system, which we'll be detailing during this lecture, is a joint responsibility of all parties in the workplace. Yes, there's a great responsibility on the employer, but employees also have their responsibilities, their duties with regards to occupational health and safety, and we'll see later on. So as we saw, preventing accidents and injuries at work is the main characteristic of the legislation. And such prevention is dealt with by what is called responsibility system, so an internal responsibility system, and also via the external health and safety standards. So the internal responsibility system is related to mechanisms that must be established by the employer, such as a joint health and safety committee, the JHSC, that aims to combat hazards and to facilitate the right to know and the right to refuse of unsafe work. So employees, they have the right to know of any hazards they are being exposed to, and they also have the right to refuse unsafe work. So this internal responsibility system is a very effective one, and the aspect of having a committee and also a plan is mandatory in BC for workplaces which have 20 plus employees. So all companies employing more than 20 people will need to form a committee and also have a plan for the prevention of accidents and injuries. So an occupational health committee or the joint health and safety committee. With regards to the external health and safety standards, so they are the legislation, acts, regulations, etc. So legislation will usually fix the minimum health and safety standards, and they also create enforcement mechanisms. How the board, tribunal officers enforce what is required as per the legislation. Those standards, they are less adaptable to specific workplaces because they are broad, they are general, they are legislation. So it's difficult for them to be specific, and for them to be changed, legislation to be changed, as we already know. They require amendments from the legislative power, from either parliament, when it's federal legislation. In this case, it's provincial legislation, so from the legislature here in the province. So with regards to the internal responsibility system yet, centerpiece is that such internal responsibility system is established at the worksite level, which requires the employer and employees to identify and reduce or eliminate the hazards. So again, it is a shared responsibility. In each workplace party will have a duty to ensure a healthy and safe workplace. And again, all parties will be employers, workers, supervisors, prime contractors, owners, suppliers that eventually come there, corporate officers and directors. Again, focus here is on prevention. That's why all parties have this shared responsibility. The employer's duties. So employers will have a duty to take all reasonable precautions to protect the health and safety of all workers. And also, those precautions, they have to be aimed at not only the employees of the employer, but also any other workers, employees of others who are eventually at the workplace. So let's say, for example, if in your company there's security personnel from a third-party company that provides security services to you, so Your employer, your company also has the duty to take all reasonable precautions to those security staff as well. Okay, there are other specific responsibilities, and this accountability will go through all levels of management. So you see how important um, this duty is for the employers. Everyone, um, every parties in the levels of management um, will be accountable for those duties. Still with specific duties for employers, so they have to comply with all the legislations, ensure workers know about the hazards, workers know about their occupational health and safety rights, policies. They have to establish and policies and programs, and also train employees, everyone at the workplace with regards to those policies and programs. They have to provide and maintain protective equipment, devices, clothing, keep accurate records on the hazards, but also on any accidents that took place or injuries, etc. They have to provide information, training, and supervision. Copies of any legislation have to be available, readily available to workers if they need. Employers still need to help the joint health and safety committees while carrying out their duties. They have to cooperate with officers, occupational health and safety officers, report properly report accidents and injuries, and cannot employ underage workers unless there's judicial authorization. So those are the main duties of the employers. Workers, their main duties, and again, everyone, including all levels of managers and supervisors, their duties are to work in compliance with legislation, in other words, statutes and regulations, acts. They have to use, wear protective devices or clothing, report any known workplace hazard, including any missing or defective equipment. They cannot engage in any horseplay or conduct that would endanger themselves or any other workers. They also have to ensure their ability to work is not impaired by alcohol, drugs, or any other causes, mental issues, for example. Workers also have to cooperate with the Joint Health and Safety Committee and with uh, occupational health and safety officers. Supervisors, their duties, they are a bit distinct because they are supervisors, so more importance is put on them in terms of occupational health and safety duties. And their duties come from the regulation, and they are to ensure the safety of workers they supervise. So if they see an employee, and even though the worker um, is responsible to use the protective devices or clothing, at the end of the day, it is the duty of the supervisor to ensure that the worker is wearing the protective equipment. If not, and if they don't have one available, it is the duty of the supervisor to send the employee home. Remember, we saw this before, and the employee would only be entitled to the actual hours worked. So supervisors also need to know and comply with all rules, Workers' Compensation Act rules, and the Occupational Health and Safety Regulation rules that are relevant to their workplace, the workplace they supervise. They have to ensure workers are aware of all the hazards they are potentially exposed to. They have to work with the Joint Health and Safety Committee and they also have to cooperate with the Workers' Compensation Board officers. For others in the workplace, so prime contractors, they have to ensure coordination of all parties at the workplace um, in a way to comply with the Workers' Compensation Act. Owners, they have to provide and maintain a premise in a way that ensures health and safety, in a way that it is compliant with the Workers' Compensation Act, the regulation, and any other legislation. Suppliers, they have to provide the tools and equipment for safe operation, and they also have to ensure that any designated substances or hazardous materials comply with the Act and regulations. Officers and directors, so the highest level in the company, they have to take all reasonable measures to ensure compliance with Act regulations and any orders. So they usually delegate to managers and supervisors, but at the end of the day, they are also liable, and as we'll see, personally liable for any offenses or any violation of regulations and acts. With regards to the workers' rights, so there are three fundamental rights under the Workers' Compensation Act, and the first one is workers, they have a right to participate in the Joint Health and Safety Committee and processes, but remember, only for companies that employ 20 employees or more. Workers also have the right and responsibility to refuse unsafe work. So this is not only a right, but it is also a duty, a responsibility to refuse unsafe work. And they also have the right to know of any workplace hazards they are exposed to. So there's this information system called the Workplace Hazardous Materials Information System, available at whmis.org. So companies usually rely on information available in this website, plus any suppliers' information and so on, to inform workers of any hazards they are exposed to. With regards to the right to participate in the Joint Health and Safety Committee. So what is this committee? This is an advisory group of workers and management representatives who will meet regularly to discuss any concerns related to health and safety. They may also review any progress and make any recommendations they find fit. Again, mandatory for companies with 20 or more employees, or for companies where the Workers' Compensation Board orders one. So because they investigated or because they received a complaint, so they may order for companies that have fewer than 20 employees. And at least half of the members of the committee must be workers. The employer cannot hold majority, so that the committee is not biased towards the employer. And the employer cannot interfere with the choice of worker representative to the committee. So the workers themselves will have the right to choose their representatives for the committee. Major functions of this committee will be to identify any unhealthy or unsafe work situations, also advise on systems for addressing any risks in the company, also to consult workers and employers on safety matters, advise employer on programs and policies that are required under the regulations, and also monitor the effectiveness of those programs and policies. Participate in health and safety inspections, investigations, inquiries, even when it includes responses to complaints. And there are some other functions that are detailed in the Workers' Compensation Act, Section 130. The worker's right and duty and responsibility to refuse unsafe work. So this is set out in the the Occupational Health and Safety Regulations, Section 312. So the workers have a right, but it's not only a right, I'm emphasizing this, it's also a duty to refuse work where they reasonably believe that the work creates undue hazard to themselves or any other person. And this unsafe work may be related to a condition of equipment or physical condition of the workplace or a violation of occupational health and safety legislation. Could also be related to the impairment of a colleague, of another worker. Some occupational restrictions will apply here because some job duties and some occupations, they are inherently dangerous. For example, police officers, first responder. So those occupations or those jobs, they will not have a right in principle to refuse unsafe work. And the Occupational Health and Safety Regulation expressly prohibits the employer from dismissing or otherwise penalizing the employee that eventually exercises their right to refuse unsafe work. But refusing unsafe work is not coming to your boss saying, hey boss, I refuse because I have a right and a duty too, so I refuse unsafe work today. I'm going home and I'll be watching Netflix for the whole day. This is not the way it works. The way it works is there are some stages. So if you believe your duty that day is unsafe, could be because of equipment, the premises conditions, as we discussed. So the first thing you have to do, stage one, you have to immediately tell your supervisor or boss or manager and state the reasons. And then the supervisor, the employer, will investigate immediately the situation and will either remedy the situation or inform the worker that the worker's refusal lacks validity. So if this is the case, if the situation is not remedied and if the employer denies uh, the unsafe condition of work, then the worker can ask the supervisor to investigate further in the presence of the worker themselves and also a representative of the committee, the Joint Health and Safety Committee or union, if there's one. If the employer is still refusing that the employee's uh, refusal to work lacks validity, so the employer and the worker must notify a workers' compensation board officer who will then investigate as soon as possible. And then the Occupational Health and Safety Workers' Compensation Board officer, they will make a decision and they will order any corrective action if appropriate, or they will confirm that the refusal lacked validity. Okay. This decision from the officer can be appealed. So it can be appealed to the appeal board or the tribunal. Okay, so that's how it works. If the employee wants to exercise their right, but also duty to refuse unsafe work. So there's a question here. You may pause now. So an employer may ask an employee to perform work that another employee has previously refused for safety reasons, as long as the second employee is a member of the Joint Health and Safety Committee. So the answer here is false. False. An employer can ask another employee to perform work only if this other employee was informed that a previous employee refused work for safety reasons. So this means that the employer needs to give a chance to this other employee to also assess the situation, whether they believe it is safe or unsafe to work. And then if the second employee believes it is safe, because the second employee also has the right and duty to refuse unsafe work. But if the employee believes it is safe to work, then it is fine. But the employee needs to be fully aware that a former employee refused and their reasons. And this second employee doesn't need to be a member of the Joint Health and Safety Committee. All right, so moving on. We talk about violence and bullying because they are also known to be hazards at the workplace. So violence is known to be any threatened and could be attempted or actual conduct that is likely to cause physical injury. So it doesn't need to be an actual conduct, but it can be an attempted one. So this is important to know. And harassment is any unwanted physical or verbal behavior that offends or humiliates and that persists over time, or when this unwanted physical or verbal behavior that offends or humiliates is a serious one-time incident. So it doesn't need to persist over time if it is a serious one. So employers, they have the duty to address, they must address incidents of violence and harassment at the workplace. So it is part of a general health and safety duty. And the regulation, the Occupational Health and Safety Regulation, also imposes specific duties with regards to violence and bullying, such as risk assessment of the workplace violence, instructing workers to identify and respond to violence by reporting, by bringing this to committee if there's one, and employers also have to create written policy and procedures for violence, and this is usually called the Workplace Violence Program. And in 2013, the Workers' Compensation Board in BC expanded the scope of violence that now includes bullying and harassment, meaning employers must now hold workshops for all employees on how to avoid bullying and harassment. So this is part of occupational health and safety responsibilities for employers. The right to know. So we discussed about the right to participate in a joint health and safety committee. We discussed about the right to refuse and also a duty to refuse unsafe work. And now we discuss about the right to know of the workplace hazards and hazardous materials. So workers, they have the right to know about any potential hazards that may include machinery, processes, and substances. The WHMIS I mentioned briefly before. It is the Workplace Hazardous Materials Information System, which is a national information system that applies to all industries and workplaces in Canada. In February 2015, federal legislation for WHMIS was aligned with the global harmonized system that classify and label chemicals, and all provinces have been working to harmonize their legislative frameworks with this new federal plan with regards to hazards. The employer's responsibilities with regards to those hazards and hazardous materials are to prepare and maintain an inventory of hazardous materials, label all those materials, prepare and maintain what is called a safety data sheets, SDSs. They were formerly called MSDSs. And the safety data sheets, they must be readily available to workers who are eventually exposed or may be exposed to them. And employers also have a responsibility to provide training to workers who are exposed or are likely to be exposed to those materials. With regards to the external health and safety standards we discussed, or I told you before, which is actually related to legislation, to laws. So there's extensive, detailed standards that will be applicable to employers or to particular industries, occupations, and trades. For example, procedures for operating and maintaining equipment, ventilation procedures, temperature procedures, cleanliness, exposures to chemicals, etc. Because they are external and they are extensive, um, quite dense, enforcement is a key issue, but they do exist, and employers should um, in, employ should apply them those standards as much as they can. Now, the accident investigation procedures. So, in case there's an incident or accident, um, investigation has to take place as soon as possible after the injured worker receives medical attention. So, again, medical attention is first here, top priority. First, you provide medical attention and then you start investigation. Um, a WCB report has to be prepared and filed with the Workers' Compensation Board, and then a statement from the injured worker, whenever possible, has to be obtained. Equipment will be examined, photographs taken, samples as well. Employer would need to interview witnesses, if any, have someone witness the interview as well to bring more protection to the employer to avoid bias or any other process issues here in terms of unfairness. And then prepare and have witness statement signed. Employer or even worker or other workers cannot tamper with the site. Employer would need to develop, implement a remedial action plan based on that accident investigation. And during the occupational health and safety investigation, they should also consider the right to counsel, usually when the Workers' Compensation Board officer is involved. So the employer should consider their right to counsel, to legal support. So how is the occupational health and safety legislation enforced? The primary aim of enforcement is to settle violations by mediation. So a mediator will try to settle the violation. And then there are two other approaches to deterrence, which are, first is the administrative penalty, which is a financial penalty for more commonplace violations. They are usually subject to appeal. And there's also criminal prosecution. And this is more for serious violators, but the burden of proof here is difficult because it has to be proved beyond a reasonable doubt. So it's a bit difficult, not impossible at all, but a bit difficult to criminally prosecute violators of occupational health and safety, but not impossible. What is most common will be the administrative penalties, and we'll see some in a minute. So there's a department safety inspector from the Occupational Health and Safety Board system. So this inspector, they have broad powers, and they may come because of an incident, or it can also be random for random inspections. And their powers, they include entering the workplace anytime without a search warrant. Exceptions will apply here, for example, for personal dwelling, um, but no search warrant for business premises are required. Those officers, inspectors, sorry, they can also conduct tests at the employer's expense. They can request identity information of workers. They can speak to anyone in the workplace and speak to any worker privately. They can compel production of any documents, remove an equipment, machine, or device for testing. They can also order work to be stopped. So they have very broad powers because occupational health and safety is top priority in the workplace. Any employer who eventually get an administrative penalty, um, be a part in a violation, this employer can make use of what is called the due diligence defense. So offenses under the occupational health and safety, they are strictly liable. They are of strictly liability. In other words, it means offenses there, they do not require intention or even negligence. As long as the legislation, the act, the regulation, they were not complied with, they were violated, the offense is there. So again, intention is not required. It could be because the employer was careless or because the employer was not aware of that duty, responsibility. Well, the reason doesn't matter. As long as the offense took place, the offense is there. So that's why we call it strict liability, because intention or negligence, they are not required. And the due diligence defense is actually an attempt to show that every reasonable precaution was taken. But even though there was an accident, unfortunately, there was an accident, but the employer took all reasonable precaution. And this due diligence defense is actually a health and safety program, which includes a designated senior manager that is responsible for compliance of everything related to occupational health and safety. It also includes the development of a health and safety policy, providing safety orientation to everyone at the workplace, conducting regular inspections. There's more. Holding monthly safety meetings, um, supporting and responding to the Joint Health and Safety Committee, training all workers in their rights and responsibilities, ensuring managers and supervisors are instructed on their obligations, disciplining those who fail to comply. Disciplining is very important because condoning should apply here, and condoning is very negative, could be an issue to the employer. Having a director that is responsible for occupational health and safety within the company, holding annual compliance audit, implementing safety recognition system, and also keeping equipment in good order. So if an employer uh, is convicted of an occupational health and safety offense, and has developed such health and safety program, they may present a due diligence defense, and most likely they may be successful in their defense if they have followed all those 13 steps or as many as possible here. So what are the penalties? So who has to prove that they did not violate, they did not commit the offense? So the employer has to prove. That's why we say the onus of proof is on the employer. And penalties, they may apply to individual and corporate employers. So they are both persons. Maximum fines here, and those fines, they have been, I just updated them some days ago. So they are effective as January 1st, 2021. They are updated every year for to match inflation rate. And for first conviction, over 700,000 plus almost 40,000 per day if the offense continues. And then for subsequent convictions, it's double, almost. So it's 1 million. There's one more number here that I would need to correct. I will correct in the slide. So there's a typo here, but it's almost 1.5 million plus 74,000 per day in which the offense continues. Okay, so it's very, very high. Those fines are very high. And there's also criminal liability. So the criminal code makes it a crime not to take reasonable steps to prevent harms that arise from work, bodily harms that arise from work. And hence, organizations are now liable for those offenses, and also by actions by several employees. And maximum penalties here will include fines. There are no maximum for major offenses, for criminal offenses, and there's even life imprisonment available for some offenses. So how serious this may be. And because we are in this COVID moment, it is also important to mention that the occupational health and safety legislation does not require pandemic preparedness, but they do require some pandemic safety measures. And they are providing credible, up-to-date information, minimize interactions, social distancing, now mainly for COVID-19, altering physical workplace as much as needed, higher standards of cleanliness, extra stocks of critical supplies, screening customers, suppliers, and the public, avoiding unnecessary travel, providing personal protective equipment, also making any changes to absence management policies that may be needed, and working from home. So this is new, and this may be in place for some time from now. So a very important chapter. You saw a lot of duties, so employers may have great liability. So they should be very knowledgeable, and they should be complying very strictly with all occupational health and safety legislation. Thank you, and I'll see you in the next chapter.